Welcome back to RR Corporates. Now we are discussing on reserved matters in the companies. This is a powerful mechanism often used in articles of association and shareholders agreements to safeguard the rights of the shareholders and shareholder groups. These reserved matters are not directly defined in the Companies Act 2013, but they operate within the framework of the Companies Act. They are especially important in case of compromise, settlement of disputes, investment transactions, and joint ventures and private equity deals. So I'll explain you what is this reserve matter. What is the meaning of this reserve matter? Reserve matters are specific decisions. These are specific decisions of the company that require affirmative vote, or we can say prior consent of certain shareholder group or nominee director. This is in addition to the normal majority requirements. So in simple terms, even if the majority agrees, the resolution cannot be passed unless the protected shareholder group also agrees. So this ensures the importance and the important corporate decisions are not taken unilaterally. So the important corporate decisions cannot take unilaterally, and the rights of the minority or strategic shareholders are not diluted. And I will explain the legal provisions or legal foundation under the Companies Act 2013. While the Companies Act 2013 does not use the phrase reserved matters, and that concept is rooted in section 10. There are various sections, I'll explain you. Section 10, which makes the articles of association binding on the company and all the members. And if you see section 5 of the Companies Act, which allows companies to include additional matters in their articles beyond the specified in the Act. And even section 241, section 242, which deals with operation and mismanagement. So reserved matters are often introduced during the compromise, settlement, or arrangement of such disputes. Even in section 43, section 47, section 106, these are all relating to voting rights of shareholders. Section 188, related party transactions, and section 180, section 186, where specific shareholder or board approvals are required. So the reserved matters are an additional contractual safeguard embedded into the articles or shareholder agreements, but fully enforceable under the law. I'll give you an examples of reserve matters. It may vary from company to company, but typically it includes board level reserve matters. See, these board level reserve matters includes like alteration of memorandum of association, alteration of articles of association, approval of mergers, amalgamations, or restructuring. These are all subject to members' approval only, and even issuance of new shares or convertible instruments, and borrowings and lending beyond specified limit. Any limit they can mutually agree. Sale or disposal of substantial assets, appointment or removal of KMPs, approval of related party transactions above threshold limit, and change in the line of the business. So these are all we can say board level reserve matters. Also we can keep shareholder level reserve matters. If you come to the shareholder level reserve matters, again alteration of share capital, the capital structure, variation of rights attached to shares, any reduction of capital or buyback of shares, because these matters first has to be come through board and then come to the shareholders. Change in dividend policy, approval of scheme of arrangement or compromise, sale of whole or substantially the whole of the undertaking, winding up the company, any amendment to reserve matter, the provisions. So we can say these are all these reserve matters through board level and shareholder level. So these can be clearly drafted either in OA or their shareholder agreement. What is this concept of affirmative vote? What is this affirmative vote? The key features of the reserve matters is the requirement of an affirmative vote. This means a resolution will be valid only if the nominee director or the shareholder group gives a positive consent, even if the majority has already voted in the favor. So it effectively works as a protective veto. So the practical cases of reserve matters: private equity investments, where investors demand protective rights, and joint ventures to ensure neither party takes a critical decisions without the other, and family owned business, where the founding shareholders retain control, and in compromise and settlement cases under NCLT, where minority shareholders agree to withdraw the litigation subject to such safeguards. How reserve matters are incorporated, how they will incorporate it. They can be incorporated in two ways. One is in articles of association, other one is in shareholders agreement. In AOA, amendments made under section 14 of the Companies Act 2013, this is binding on all the members. In shareholders agreement, a contractual arrangement among the shareholders for enforceability against the third parties, such clauses are usually mirrored in the articles. Even you enter in shareholder agreement, for enforceability against the third party, such clauses are generally mirrored in the articles. We'll completely draft the same in the articles of association. And also dispute resolution. If reserve matters or reserve provisions are violated, then the aggrieved shareholder group may approach the Honorable NCLT under section 241, 242 of Companies Act 2013 for operation and mismanagement, and enforce rights under shareholders agreement through arbitration if an arbitration clause exists. So seek remedies under Companies Act for invalid resolutions. So my final conclusion is these reserve matters act as a corporate safeguard mechanism, ensuring that significant decisions are not taken without the participation and approval of the key shareholders, which we are defining. For companies, even for companies also, it is helpful to maintain the balance and prevent disputes. Even for investors angle and minority groups, they serve as a shield against the arbitrary decisions. If you found this video helpful, don't forget to like, share and subscribe. We have two channels, RR Corporates and other RR Legal Talks. Thank you.